What is an Arthur hearing? I'm attorney Danny Izquierdo of the Izquierdo law firm. An Arthur hearing is a bond hearing of sorts in the state of Florida. See, most people that happen to get arrested in Florida are entitled to a bond. There's even a standard bond schedule where somebody can get arrested and pay the bond immediately or go to see the judge the next morning and pay the bond shortly thereafter. However, there are charges in Florida that are considered not bondable. That means the person is to sit in jail with no bond while their case is pending. You can, in Florida, request what is known as an Arthur hearing. So even though the law states that based on your charges, you are not to receive a bond, as long as the state hasn't moved for pretrial detention and the court granted that motion for pretrial detention, you have every right and should explore the possibility of filing a motion for bond and requesting what is known as an Arthur hearing. And an Arthur hearing is a very specific, special type of hearing where the only question is, should the court exercise its discretion and give somebody a bond when they were otherwise being held on a non-bondable offense? Arthur hearings are broken up into two phases. And in phase one of an Arthur hearing, the burden is on the state, on the prosecutor, to offer evidence to convince the court that the proof of guilt is evident and the presumption is great. This, in theory, is the highest burden in our criminal justice system. It's even higher than beyond a reasonable doubt. What happens in an Arthur hearing is that the prosecutor presents a very limited view of the evidence, tells a very short and concise story. And this early in the case, discovery sometimes isn't complete. Depositions probably haven't been taken. So even though it's a very high burden, it's a burden that they oftentimes are able to meet. And that burden, once again, is the proof of guilt is evident and the presumption is great. Now, regardless of what the court decides during phase one, the state met its burden or didn't meet its burden, we then proceed to phase two. Now, phase two, the burden is on the defense, and that's where we are trying to convince the judge to use their discretion and give our client a bond and some sort of conditions of release so that they can fight their case on the outside and not have to sit in jail while the charges are pending. This is where we really try to put on a presentation for the court. We bring a good cross-section of our client's network, of their people, not just family members that are going to say how great their uncle, cousin, brother, sister, husband, or wife is, but we really try and mix it up in order to accurately tell our client's story. And we try to do that so that the judge feels comfortable that even though this person is charged with a very serious crime and they're considered non-bondable, that they could comfortably exercise their discretion. And there's a way to give this person a bond while also protecting the community. And that's really what the court's trying to figure out during any kind of bond determination, but especially during an Arthur hearing determination. Is this person going to come back to court to face the case and the charges? And can I protect the community? That's essentially what this all comes down to. If somebody you know and love happens to be charged with a non-bondable offense, don't lose hope immediately because not all is lost. Our firm has successfully represented individuals at Arthur hearings. We have secured bonds for people charged with armed robberies, people charged with attempted murders, people charged with capital sex crimes, lewd and lascivious molestations. There is a way that we like to handle our Arthur hearings, which has proven very successful in a lot of our cases. So even though you're facing some very serious charges and your loved one is considered not bondable, it doesn't mean that they can't eventually get a bond. Give us a call, schedule a free 4-point case evaluation defense strategy session, and we'd be happy to go into greater detail how we might be able to help your loved one.